So this is a kind of a part two to my first contracts workshop that I did. For those who attended it, you'll remember some of the concepts, some of the laws behind it. With this with this workshop today, we're going to be putting theory into practice. I didn't have enough time for the last workshop to go over actual real world contracts, and so I'm going to take the opportunity today to go over some of those contracts with y'all, and you'll learn, how to review a contract, how to draft a contract if you're looking to do that yourself for your business. We're going to go over all of it today. So let's get started here. So some of the takeaways from the lecture, building off of the last workshop, you're gonna learn these things. What is a contract? When is a contract necessary? So if you're entering into a business transaction with somebody, whether it's for services or you're selling products, are you required to put that contract into writing, or can you do an oral contract? And what is a contract when it's fully formed? What's the elements behind it? What makes that contract enforceable? What happens when there's a breach of contract? Somebody that you're entering into a contract with doesn't fulfill their duties, responsibilities. It's a breach of contract. How do you get out of breach of contract? And so, what are some of the basic provisions that you would want to include in a contract for your business or yourself, depending on the nature of your business and what you do? So, just to do a brief overview, if you remember from the last workshop, we talked about the importance of contracts. As a business owner, as an entrepreneur, contracts are going to be one of the primary documents that you're going to use, that you're going to draft, that you're going to review for your business. And it's important because it's the contract that will protect yourself and your business as you move forward conducting business with your customers or clients. Not all contracts have to be in writing, contrary to what you might hear. There are contracts that you can make orally, but what are some of the instances where you would want to put a contract into writing? And we went over that last time. When it comes to contracts, there's two sources of law that will govern any contract, and it varies depending on the jurisdiction or the place that you're engaging or entering into the contract. You might be on an Indian reservation, Navajo Nation, Hopi Nation, Pasquayaki, Tanatam, wherever you're at. If you're on an Indian reservation and you're entering into a contract, it might be that the tribal law will apply to the contract. What constitutes a valid contract, how you interpret that contract, how you enforce it, might come down to tribal law. Now, if you're in Arizona, let's say that you're in Phoenix or you're in Albuquerque, New Mexico, you're within a state jurisdiction. And so if you enter into a contract in a state jurisdiction, there's this body of law that might govern the interpretation and enforcement of that contract. And that body of law is called the Uniform Commercial Code, also known as the UCC. So the UCC and the common law work together to interpret and enforce contracts. So these days, most of the time, if you're dealing with contracts between merchants, let's assume that you're a business owner and you sell clothing, and you have a supplier that's going to supply you with t-shirts. And when you engage in contract with that supplier, it's a merchant to merchant contract. And so that would be subject to the UCC Article 2, because that would govern sales and also leases. So if you're engaging in lease agreements as well, Article 2 of the UCC would apply. So that's just some of the basic, terminology behind, contract law. You have the common law and the UCC that will govern interpretation and enforcement. So just remember that. And in fact, if you're in a state jurisdiction, let's say you're in New Mexico and you want to see the UCC, it's as simple as going to Google, typing in New Mexico UCC, and it'll pull up the New Mexico UCC. Almost every single state has a UCC. You can Google it. It's all free for you to view. It's all online, depending on the state that you're in. I always recommend that people, especially business owners, become familiar with Article 2 and what that says. So if you remember from the last workshop, we talked about what is a contract, and there's six elements. Well, I would say three elements and three considerations to a contract. And what those are number one, an offer, number two, acceptance, number three, consideration. If you go to law school, your law professor for contracts is going to teach you these three elements: offer, acceptance, consideration. Those are the primary basic elements to a contract. Somebody has to make an offer to you. You have to accept that offer, and then it has to be supported by consideration. And typically, consideration is going to be some kind of form of payment. But at the same time, you can have these three elements, but you also have to meet three considerations. Number one, legality. Number two, capacity. Number three, mutuality of contracts. So just very briefly, again, we talked about the offer, right? A clear offer that you'll make is I will sell you my car for $5,000 cash, right? That's a clear offer that you're making. And when it comes to acceptance, clear example, I'll pay you $500 if you ride that mechanical bull in the bar downtown while wearing a skirt. You can accept by mirroring the terms. Okay, I accept. I will ride that mechanical bull in the bar downtown while wearing a skirt. Or you can accept by performance. So you can accept an offer by just performing what they're asking you to perform. So that's acceptance. So we have offer, acceptance, and consideration. Now, the general rule behind consideration is that consideration is anything of value, and it can, most of the time, it's probably going to be money, or it can even be a promise to do something or not do something, but you had a right to do. If you're promising to do something without consideration, it's considered a gift, right? So there's a difference between having a legally enforceable contract and then having a contract that's not supported by consideration. There's no monetary value behind it. Well, that might be considered a gift. So those are some of the nuances that we have to keep in mind when we enter into contracts. Now, for legal purposes, most of the time, courts will not look into the adequacy of consideration unless it's absolutely, completely unfair, ridiculous, doesn't make any sense, right? So if I'm making an offer to Sophia and I'm saying, "Hey, Sophia, I'll sell you my brand new Mercedes AMG 2025 edition. I'll sell it to you for $1." And Sophia says, "Great, I accept. I will pay that dollar and for your Mercedes AMG 2025." And then eventually time comes to sell the car, I don't want to sell it. Sophia will say, "Well, hey, I accepted the offer." And I can say, "Well, look, the consideration for that was way too low." And she sues me, we go into court. Now, typically courts will not say, "Well, that's too low of a monetary value to pay for that car." But if it's $1, seems kind of ridiculous for a Mercedes AMG, right? So that would be an instance where a court might say, "Look, that consideration might not be adequate. That contract is not enforceable." These are very clear examples. So again, offer, acceptance, consideration, right? Three basic elements. Now, the three considerations you have to keep in mind as well is legality of contracts, right? Your contract cannot be illegal, right? A primary example is, contracts for prostitution and something, again, you learned in law school, it's illegal, it's against the law. So you can't have a contract that violates the law and be enforceable at the same time. So the other thing is capacity, right? You got to have the capacity to enter into a contract. And typically, what courts will say is that you will have capacity as long as you're over the age of 18 and you're mentally competent. If you're acting on behalf of a company, well, there's another little nuance there. You actually have to have the authority to enter into contract on behalf of a company. So, having somebody, like let's say there's a manager of a company who's signing off on a contract on behalf of the company. Most likely he has authorization, but assume that you have, let's say, an administrative assistant who's signing off on a contract on behalf of the company. Well, there's a difference there in the roles and duties and responsibilities. The administrative assistant might not have the authority to enter into contracts on behalf of a company, so that contract might not be legally binding, right? So if you're running a business and you have people who work for you, assume that somebody entered into a contract on behalf of your company and it's your summer intern, right? Well, that contract might not be enforceable because the summer intern didn't have the authority to bind your business to any contract, right? Only you, as the chief executive officer or the business owner, have that capacity, right? Now, when it comes to mental competency, some of the issues that we see, are usually in regards to, like, let's say Alzheimer's, right? If you have somebody that you're entering into a contract with who might not be lucid at the time that they're entering into that contract. Maybe they're having some kind of medical episode pertaining to Alzheimer's, dementia, or something like that. They don't have the legal capacity to enter into that contract at that time, so that contract might not be considered a valid contract because there's no capacity. Now, the third one, mutuality of contracts. So basically what this means is there has to be a meeting of the minds that when we enter into this contract, let's say I have a contract with Sophia, and again, it's for the sale of my Mercedes AMG, and there has to be mutuality. We have to have a meeting of the minds. We have to both be on the same level in regards to terms and conditions and provisions that are going into that contract, right? You can't be sneaking in terms and provisions into the contract that the other party doesn't know about. There has to be mutuality and a meeting of the minds. So those are the six elements and considerations, to a contract. Now, again, if you remember from the first workshop, we also talked about contracts that must be in writing. Now, there's a law that's called the statute of frauds, and the statute of frauds will dictate whether or not a contract needs to be in writing. And under the statute of frauds, what it'll say is that the following contracts need to be in writing. Contracts that cannot be performed within 1 year from the contract formation, contracts for the sale of goods exceeding $500. So if you're a business owner, if you're a merchant and you're selling products and it exceeds $500, that contract needs to be in writing. And this is one of the biggest mistakes I always see, with our clients is that, when you're starting out as a business, you're selling products, you're doing well, not only, are you probably not too keen on some of the taxation laws out there, but also, contract laws. You might be selling products, for $1,000, $1,500, $2,000, whether it be in bulk or for a few products or a single product, it doesn't matter. You want to put that contract into writing to make sure that it's enforceable, right? The other contracts that need to be in writing: marriage contracts, prenups, land, real estate contracts. So, if you're leasing space or you're buying space, for your business, that has to be in writing. Executor contracts, guarantee contracts. And those are some of the examples. Now, there are contracts that can be oral. There's some jurisdictions that don't recognize this, some jurisdictions do. If we're dealing with contracts in Navajo Nation, you absolutely can have an oral contract in Navajo Nation. In Navajo Nation, the jurisdiction is interesting because Navajo Nation recognizes oral contracts. And under Navajo law, some of the case law out there, specifically one called Hood v. Bordy, which was a case decided by the Navajo Nation Supreme Court in 1991, the Supreme Court said that a valid contract in the Navajo Nation has the following elements: competency, meeting of the minds, consideration, lack of impossibility, and no public policy violation. So you can see that Navajo Nation, what they consider a valid contract, is very similar to what a state court would consider a valid contract. So many of the contract principles that you will see and that you might deal with in a state jurisdiction are probably applicable in Navajo Nation, even though it's a separate jurisdiction. Navajo Nation, they use the common law to construe a lot of contracts. So we went over that in our last workshop as well. We talked about Navajo laws and tribal laws and how they might change the interpretation or the validity of a contract. We also talked about breach of contract, right? So you enter into a contract and you want to enforce that contract on the other party. You want to make sure everybody is fulfilling their duties, obligations, and responsibilities. Well, what happens when a party doesn't fulfill their duties or responsibilities, when they neglect it or they omit it, they don't do something that they're supposed to do, whether it's, they don't invoice you on time, they don't pay you on time or something like that. That's called a breach of contract. And there's two types of breach. There's a material breach and a minor breach. Now, a material breach might be that, you're selling, again, I'm selling Sophia a Mercedes, AMG, and she's expecting to get it. She pays 50,000 for my Mercedes. And then I go in to deliver the car, and instead of a Mercedes, I give her a Kia Sorento, right? That's a material breach of contract. She was supposed to get a Mercedes, now she's getting a Kia Sorento. Material breach right there, right? She paid money for the Mercedes. A minor breach, might be something like, you're dealing with, let's say like a supplier, right? And you order, again, you have a clothing business and you order 1,000 white blank t-shirts to be delivered to your business. And your supplier, instead of giving you 1,000, they might give you 999 t-shirts and accidentally omitted one. Well, that's a minor breach of contract, right? So we treat material breaches and minor breaches different, depending on the circumstances, always on a case-by-case basis. And so depending on the type of breach, it also determine what kind of remedies that you have available to you. Is the breach so bad where you want to sue the other party, to enforce the contract? You might want to, if you're dealing with a contract, in millions of dollars or something like that. But if it's a minor breach, it might be as simple as, hey, I got 999 t-shirts. I ordered 1,000. Can you send me the other one? Sure, no problem. They'll send you the white shirt. No harm, no foul, right? You continue business as usual. Now, when there's a breach of contract, we also learned that there's defenses to breach, right? It might be that it was impossible to fulfill your duties and obligations under the contract, maybe due to weather or something like that. Maybe it was impractical to do it because initially you were going to do overnight shipping, using, let's say, aviation, using air delivery, right? An airplane was going to deliver your product all the way in Los Angeles from New York, and you planned on using, the airlines to get things delivered. Well, whether let's say that, a snowstorm hits, on the East Coast like it usually does around winter, you know, now you have to use transit, by ground. It's going to take a week to get it to Los Angeles. See, so the contract, delivering in one day using air is impractical. You can't do it due to, unforeseen circumstances. The other thing is fraud or duress, right? Somebody holds a gun to your head and says, do not do what you're supposed to do under the contract. Well, you're under duress, right? Or you entered into a contract, under fraudulent circumstances, right? You're alleging to say, hey, look, I'm the CEO of ABC Corporation and I can enter into this contract. It turns out, it's a summer intern that's entering into that contract, not the CEO. So, the contract might not be valid because, there's fraudulent circumstances. Somebody's pretending to be a CEO. The other thing is want of consideration, right? We went over this with consideration, that there's no consideration in this deal that you're making. If there's no consideration, if there's no money to support the contract, then it might be considered gratuitous, or it might be considered a gift by the courts. So it's not valid as a contract because there's no consideration underlying it. So you want to make sure that you have adequate consideration as well. And we talked about damages, right? So let's assume there's a breach of contract. Well, what are you looking for to rectify the breach of contract, right? That's what we call damages. Damages is basically a sum of money that's owed by one party to another for breaching a contractual duty or violating a contractual right. And there's different types of damages depending on, again, depending on the nature of the breach, depending on the circumstances of the case. You might be seeking money damages. You might be seeking incidental damage, reliance damage, punitive damages, other remedies, like specific performances. You might be requesting attorney's fees, right? You had to hire an attorney to represent you, to handle the breach of contract case on behalf of your company. Well, it's not your fault that the breach happened. It's the other party, and the court finds liability. So the court might order that party who breached the contract to pay your attorney's fees. But it's very important that you have a contract that states that in the event that you prevail in a lawsuit for breach of contract, you are entitled to attorney's fees, right? So you have to have that provision within your contract. Most jurisdictions will say that. Navajo Nation is one of them. In all the cases I've handled regarding breach of contract cases in Navajo Nation, the court always asks, do you have a written contract, number one? But number two, does that written contract say that you are entitled to attorney's fees if you prevail in a lawsuit? That's how the Navajo courts look at it. So, again, these are the different types of damages. Let's assume that, you have a situation where you're a heavy equipment supplier, right? And you have a client that orders $100 million in heavy equipment from you for a construction job that they're about to commence. Well, you put in the order from the manufacturer, you get all the vehicles, the equipment, the bulldozers, the tractors, all that stuff ready to go. And now you have a client, who's saying, well, actually, I changed my mind. I don't really have the funds for that. I'm going to have to cancel the order. Well, you already ordered it from the manufacturer, right? All those vehicles, those bulldozers were custom made to order. And so somebody has to pay you the $100 million, right? And it's not going to be your client. What do? You have reliance damages, right? You relied on that person, their word that they were going to purchase this equipment. Now they're trying to go back, on their word. You have reliance damages. If they're doing this, just on a fraudulent basis, you might be seeking punitive damages to punish the person for acting immoral, for acting illegal against the law, something like that. Incidental damages, right? Let's assume that you can't sell this heavy equipment to anybody because it's custom made. Now you have to go advertise to see if there's somebody out there who wants to buy this customized equipment. That's incidental damages, right? Because now you got to pay marketing costs. You got to, pay to get this equipment off your hands and to make that $100 million that you need to make. At the same time, you have a lawsuit going with the people who won't pay you, right? These are some of the things that we see in breach of contract cases. Now, this brings us up to speed, right? So we know what a contract is. We know what the elements are, what the considerations are. We know what a breach is, and we know what happens, what we should do if there's a breach of contract and what we're entitled to in terms of remedies or damages, right? So that's the first workshop in a nutshell. Now that brings us up to today, putting theory into practice. And so reviewing, drafting, and negotiating contracts. Now, the way that I break this down as an attorney who deals with contracts almost on a daily basis, when we're reviewing contracts, It takes a keen eye and a forward-thinking mind. Remember that, because this is going to come into play in a bit. Drafting contracts requires a wordsmith. I always say drafting contracts is like an art form. It takes a certain level, of writing to draft a contract that's valid, that protects yourself, protects your client. That there's a reason why, people specialize in this field of contracts. Negotiating contracts. In the years that I've negotiated contracts on behalf of, clients, or even on behalf of, myself, negotiating requires being open, right? Being fair and negotiating in good faith. Right. Some of the best contract negotiations that I've engaged in, both parties came to the table with an open mind. They're willing to communicate effectively, to listen when somebody's speaking, to be fair in their terms and provisions, right? There's some companies that out there that'll offer you a contract, and because they're a big company with, millions or billions of dollars, at their disposal, they take a very one-sided approach to contracts. They'll draft a contract that is very favorable to themselves, knowing that they might be dealing with somebody, a customer, a client, or maybe even another merchant who's a small business who might not have the same kind of business savvy or legal counsel, at their beck and call to review contracts or negotiated contracts. And so we see a lot of one-sided contracts coming from, big corporations, big businesses. But what I tell people when it comes to contracts, remember, almost everything is up to negotiation as long as you meet the 6 requirements that we just talked about. Slide 7, if you want to go back and look at it. So you'll have people, and I see this a lot with Navajo Nation, who will offer contracts and say, this contract is non-negotiable. If somebody's telling you that, you should probably take a second, to yourself, look at this contract and determine whether or not it's something that you want to enter into. You kind of got to do a cost benefit analysis, when somebody does that to you. If somebody's saying, look, here's the contract, take it or leave it, it's non-negotiable. If they're not willing to negotiate, then I would recommend, again, really scrutinizing the circumstances and deciding whether or not you actually really need this contract, because every contract should be negotiated in a way that benefits both parties. And that's the fairness aspect that we're talking about, right? Being open, being fair, and negotiating in good faith, not having fraudulent circumstances underlying the negotiation of contracts, so that's what we're dealing with here. So originally at this point, I plan to do breakout rooms to have people kind of work on their own contracts. But since we have such a small group, I think we can probably just do it together. Well, how many people we have here? About 6 people. So what we can do is we can do this exercise amongst ourselves. We can talk about it. But basically what I was going to ask people to do was to get into groups and decide as a group what kind of contract you would want to create. And once you make that decision, discuss what kind of terms and provisions that you want to put into that contract. Right. So, and during this whole exercise, I was going to ask people to create a list of the terms and provisions, as well as a brief description, for each one. Why is it that you're putting this term and provision in your contract? If you're at the point where you actually draft your own contracts, then you might choose to actually draft your own contract at this point. But, this will take maybe 10, 15 minutes. Maybe if we have a good discussion going, we can, go beyond that before we move on. So let's go ahead and start the exercise. Let's see. All right. So let's decide on the first one. Let's say that we're going to create a contract. So who here has an idea of what kind of contract you want to create? If we have business owners who are attending this workshop, what kind of contract would you like? Maybe you want a service contract, independent contractor agreement, sales agreement. What do you think? What kind of contract should we create?
Let's go with a sales agreement.
Sales agreement. All right. And Albert, are you a business owner?
Yes.
All right. What's your business do?
Create custom software.
Great. All right. Sophia, do we have a whiteboard that we can use?
I think so. Yeah, let me get
Yeah. Can we make a list on the whiteboard while we're discussing this? So we're going to do a sales agreement here. Joe said he's going to employ my services for the AMG.
Can you see my screen?
Yes.
Okay, go ahead.
Okay. So we have a sales contract or a sales agreement that we're going to make. Contract agreement, doesn't matter, what we call it. So let's call it a sales agreement. So for everybody, anybody and everybody, chime in if you see an opportunity here. So what do we need to put into our sales agreement? So remember, think about the considerations, think about the elements, and then also the nature of your business. So what do we need to put in here?
I'm guessing the obvious terms and conditions.
All right, terms. What's the obvious terms and conditions that we got? So Albert sells software, right, Albert? So you're selling software to your customers. So if you're selling software to somebody, what do you need to put in there to make sure that your business is protected, to make sure that it's fair, it's a fair agreement amongst you and your customer or your client? What would go in there? What about price, right? Price. How much are you selling it for? Mary says deliverables, expectations, great, right? So what exactly is the deliverable, the final product that you're giving somebody? Clinton says services, right? So if you're providing services to somebody, what services are you going to provide, right? You might want to take a scope of services and attach it to your contract and say, see Exhibit A. These are the scope of services that we will be rendering for the client. And again, your contract. So we have a price, we have deliverables, expectations, we have scope of services. What else should we put in this contract? Think about how you're going to protect yourself, right? Dispute resolution, great. So we got dispute resolution. Let's see, we got Mary also said timeline, time frame. So dispute resolution, we got a timeline also. So we have deadlines too, right? So let's say Albert is developing software and for a client, and the client needs the software within 90 days, right? So there's a timeline there, there's a time frame, or you see this a lot in construction contracts, right? Construction contracts can go hundreds of pages, but you need all that stuff in your contract, like a project timeline, when what kind of permitting do you need? What kind of licensing do you need? When are you going to get this done? Phase 1, phase 2, phase 3. So you might want to consider having a project timeline in there, depending on what you're doing. Mary also said termination clause. And that's good, termination clause. The termination clause also, you might consider cancellation. What happens if you want to cancel a contract? So not only do you want to consider how to protect yourself, but you might also want to consider how do you get out of this contract, right? You might want to create a way out for yourself where you're not in breach of contract by canceling the contract, right? So those are your cancellation clauses that you might want to insert. Albert says a licensing agreement, right? So let's assume that he's developing the software, and instead of selling the software outright, to his client or customer, he's going to license it instead. They might pay, let's say, a monthly fee to use Albert's software. So he needs a licensing agreement. So the license agreement or clause, depending on how you want to draft it, you might want to consider a whole separate licensing agreement, or just putting the licensing clauses into your sales contract or your services agreement, something like that. So there's different ways to go about it. And Mary says determining who is responsible for space, supplies, etc. Now this is an interesting one. Mary, can you elaborate on why you're saying space and supplies and responsibility? What are you thinking?
Hi, Joseph. Hi, everyone. I was thinking along the lines of, like printer ink or supplies that are used, those get pretty expensive, and, determining who's going to be responsible for that. And I was just getting ready to type it in the chat as well, reimbursements for like meals, mileage,
Right.
and things like that.
Exactly. Great points. So Mary is hinting at there's another agreement that I think most people are going to use in their business, and that's called an independent contractor agreement. So let's assume that, let's say, again, let's use Albert's business as an example. Albert is developing software, and his client is requesting that the software be done and ready for licensing within 90 days. Well, Albert knows that a project of this magnitude is not going to take 90 days. It might take more than that. So he has to hire some people to help him out. And so Albert might hire another freelance software developer. Let's say Joe Austin, he's going to hire me to help him out with his software development. So he has to put me under an independent contractor agreement, and that agreement will make the determinations of who's going to pay for supplies, what space am I going to use, am I entitled to reimbursement? Let's say that I got to travel to Albert's office in Tuba City. I got to spend, let's say a month there, and I got to stay in a hotel in Tuba City and all that. And am I entitled to travel? Am I entitled to meals, reimbursement for any kind of expenses, hotel, travel, all that kind of stuff, you might want to put that into an independent contractor agreement, right? Or even whatever agreement that you might be dealing with. If you think it's necessary to protect yourself, I would say include it, because again, contracts are always up for negotiation, right? And that's the thing we have to keep in mind is just because we draft this contract the way that we like it, keep in mind you're dealing with another party as well, right? They also have to be on the same page as you and agree to your terms and conditions. I've never seen a contract negotiation where one party offers the initial contract and says, look, this is our offer, and the other party says, great, we'll take it, and they sign off on it right there without reading it. Never happens. Contract negotiations go back and forth depending on the transaction, depending on the parties, the nature of the transaction, what's underlying the contract. Some of these negotiations can take days or weeks or months, or if you're dealing with Navajo Nation, years. Yes, Navajo Nation does take a long time through their DOJ office to give you a contract. So, and Navajo Nation, again, they'll offer you contracts and tell you, take it or leave it. You cannot negotiate this contract. That is 100% false. I always say every contract can be negotiated, and I've managed to get contracts edited and amended on behalf of my clients when we're dealing with Navajo Nation. So we have this, right? We have the sales agreement, we have independent contractor agreement. What other provisions should go in here? We dispute resolution, termination clause, project timelines, reimbursement. What else are we looking at? What do you think? Anybody? Think about some of the contracts that you've seen or you might have been offered for your own business. What kind of contracts what kind of provisions would you put in your contract?
One I came across is like a cap on like the payment.
Okay, a cap on payment. What kind of payment?
So like you can give them your hours, but they give you a cap of how far you can go in terms of to not exceed.
Good. Great. Right. So again, if we're dealing with, let's say, services, take my law office, for instance, we have a law office that's rendering services. I might be dealing with a client. Let's say that I'm drafting contracts. I'm drafting contracts for my buddy Joseph over here. And he's selling Mercedes AMGs all over the place. And he wants to get a contract. Well, he hires my office and says, look, my business is kind of on a budget. I only have maybe $10,000 to dedicate, to this contract that you're going to be drafting. Can you work within this? That's going to be the cap. Sure, I can try to work within it. You might not get the contract that you're looking for, but I'll try to work within that budget, and we put it into an agreement. And let's say that I draft this contract and I give the final invoice to Joseph and I say, all right, $15,000 for this. He says, wait a minute. We had a contract in place that said we capped it at 10,000. There we go. Protecting yourself with your contracts. We have hands up here, Clinton.
Yeah, hello. My name's Clinton, man. Hello, everybody. Barely getting to learning all this stuff, and I think say independent contracting, would it be under say, because I'm trying to start a tire shop business for a mobile service, because people are getting Tauruses are getting having they're having difficulties with their tires and stuff on the side of the road. I would provide them their road assistance. You know what I mean? And charging their premium, because I know those Tauruses, they have premium services. They pay premiums for insurances, and I can charge them the premium how much I want. Because being under this independent contract agreement, right?
Right,
And,
right. So basically, if we have this roadside tire service,
yeah,
and let's say that you have a website,
yeah,
and you put on your website exactly what you do. Hey, look, you get a flat tire in Navajo Nation. Doesn't matter if you're in Windoruck, Kayenta, Tuba City, no matter what, I'm going to come out. I'm going to save you. I will fix your tire. I will do all this kind of stuff. You put it on your website. That's an offer that you're making, right, to people through your website. You're saying, look, this is what I'm willing to do for you, and this is the price that I will do it at, right? So let's say somebody calls you up and says, hey, Clinton, I run a tour company, and we have 20 buses that are constantly going back and forth across Navajo Nation, on a daily basis. And if there's a tire blowout, we want to make sure that you're on call to fix the tires for our buses. And so they're saying, if we have a contract with you, let's say a services agreement, can you negotiate on your prices? Can you give us a 10% discount because we're bringing so much business to you, right?
Yeah,
So
me and Ron,
Right. So that might be the kind of agreement that you're looking at with somebody. Now, you're going to have those instances where, somebody gets stranded, let's say in Tuba City, and if they have reception out there, they're looking for tire service and they Google Navajo
Yeah,
Nation flat tire service, and then your name comes up in your business.
yeah,
Well, they might just look at your website, say, "Hey, look, this guy can fix our tire." And they call you up. Can you come out here?
yeah. There'll be reasonable prices too. Not like an arm and a leg. Like how Alabama
Right.
is.
So somebody is coming out, or somebody's calling your business and saying, "Hey, Clinton, I need you out here to fix my tire within the next 2 hours." Be sure, right? They offered to pay you. You're saying yes, you accept it, and you're saying I will do it at a cost, let's say $250 because it's an emergency situation. So
Yeah,
you'll charge $250. They
yeah,
say, sure, great, sounds good. And they accept it. You come out. So you have offer acceptance consideration, right? It's a legal contract. Both parties are on the same page. There's mutuality. There's good faith here. It sounds like an enforceable contract. And here's the thing, it's an oral contract. And if you're working in Navajo Nation recognizes oral contracts, right? So that is a valid oral contract. Somebody hiring Clinton to come out, repair their tire within 2 hours, that's a valid oral contract. Now, let's say that Clinton fixes a tire and then people say, here's 150. And he says, wait a minute, I said 250. And then people said, well, I don't have 250. I'll pay you 150. Well, now we have a breach of contract, right?
yeah,
So people owe him $100 more. And so what is Clinton going to do in this situation? Is this a material breach? Is it a minor breach? Does he want to sue the person, to get $100 from them? He's probably going to spend $5,000, $10,000 in attorney's fees, suing this person for $100 might not be worth it, right? Those are some of the situations that you're going to come across as a business owner, as an entrepreneur dealing with customers and clients. I deal with clients all the time, and I can tell you, dealing with clients and customers can get pretty rugged at times. People will always try to renege on their contracts, even when they sign a contract. They will tell you they didn't understand it, they didn't read it. Well, not your fault. If you sign that contract, you're bound to that contract. That's what most courts would say. So, Mary, your hand is up.
Thank you for everything. Thank you.
Sure thing.
Okay, so I'm gonna put something in the chat from a contract that I recently was given. And this section there in the chat is the intellectual property rights of the
Right.
contract. Being that I'm a small business owner, there's just myself, and a lot of what I developed is my own processes. It made me feel very uncomfortable signing this contract, and I brought that to light, indicating that I wasn't comfortable with everything that was written here. Thankfully, this company was workable enough and understood where I was coming from, that they went ahead and went with my more simpler contract that did not, I guess, allow them these rights to, I guess, everything that I created. But I just want to get your feedback on that. And
So Mary, can you tell the group what is it that your business does?
I am a human resources consultant, specifically working with employee relations, so grievances, appeals, disciplinary actions, things, investigations, workplace assessments, things like that.
All right.
So
So
my processes that I'm talking about, in particular, they were interested in the mediation processes that I have in place. So my whole mediation process, everything involved in a step-by-step of how I do my mediations is something that I developed on my own. So for instance, if they wanted to, how I read this was, should I decide to sign this contract with them, then they would then own everything that I've provided and created for themselves. So because I'm not an attorney, that's how I read this, and I wasn't comfortable with it, so I didn't
right.
sign
So
it.
this is a great example, Mary, and thank you for speaking up and sharing with us this clause that you have. So let's take a look at it. Let's take a look at this clause. This is a clause that we'll see in a lot of contracts, right? This is an intellectual property clause, and you might see this if you're dealing with artistic creations, if you're developing something like Albert, right? Albert, software developer, right? He develops software. What he's developing is considered intellectual property, right? If it's something new, if it's something innovative that's subject to protection under intellectual property laws of the United States, this is when these provisions come into play, right? So let's assume that, you know, we have a situation where, let's take my sister's business. She's a freelance artist. She does painting, creates logos, she does digital design, all that kind of stuff. She creates these designs and logos for companies who need it. The logo that she's creating, right? If we have let's say she has a services agreement with her clients, and her client says, I want you to develop a logo for my consulting company. Great. Under the services agreement that she has with that customer, she's going to put in there an intellectual property clause. And that intellectual property clause says that whatever logo or design that I make for the client, you know, John Doe, you know, who's a signatory under this contract, John Doe will own all rights to that intellectual property, right? So by her creating it, it might be subject to copyright as soon as she creates it, but she is relinquishing all intellectual property rights that she has in that logo that she created. She's relinquishing it to the customer. That's when these provisions come into play. Now, again, you have to be very vigilant. Like I said in my slides, it takes a keen eye in reviewing contracts. And Mary has one of those keen eyes. She's looking at this contract saying, wait a minute, something doesn't sound right here, right? It seems to me I'm signing over all of my rights, you know, to my intellectual property or to my methods, to my processes, however you want to word it, right? So you might want to consider going back to the negotiating table and saying, look, this intellectual property clause, I don't think it applies, or we should eliminate it for these reasons, right? Protect your company, protect yourself, your creative designs, whatever it is, with provisions like these. And Mary, you're right, you know, depending on the nature of your business and what you do, you might not want to have this clause in there, but this seems like one of those typical intellectual clauses that I see in contracts. Typically, they will define the term work product. So you'll always see a definition of that term work product, because what does it encapsulate? And they'll have this long list of things that fall under the umbrella of work product, right? All patents, copyrights, trademarks, trade secrets, know-how, confidential, proprietary information, all these things, you know, these things constitute work product. And then these things constitute intellectual property, and these things are your rights. You know, that's usually what you'll see with these. But I see this a lot with freelancers, you know, who are engaged in artistic or creative services, intellectual property. So that's a very, very important clause to consider. So let's take a look at our whiteboard here. So we have a sales agreement, right? We have some of these terms and conditions that we would put in there. If we have an independent contractor agreement, you know, here are some of the terms and provisions we might want to consider putting in there. Oral contracts, we discussed that with Clinton. So we have a firm grasp. I think everybody here has a good idea of what should be put into their contract. So let's get into these terms and provisions. We know what should go into a contract, but exactly how should that language look, right? We're trying to get to the final draft here of our contract. So we're reviewing it, we're amending it, we're negotiating. How do we get to that final draft? So let's go ahead and get back to the PowerPoint here. Sophia might have to help me out.
You know, one other thing, Joseph, that I seen a more skilled contractor include in her contract. She's been in business for over 10 years, and she was sharing with us that she includes in her contracts a travel fee. At the time that she started her business, her daughter was very young. And I guess it took time from her to be away from her daughter, and then, you know, dealing with the hassle at the airports, that she added a $500 travel fee, which I thought was really interesting. And she said she's never gotten any pushback. And if they did ask anything to that, she would explain, and they were always okay with it. So I guess it kind of, if they want our services, then they're able to be workable. And I thought that was a really good example of negotiating to the benefit of us as entrepreneurs.
Right, exactly. So that's a good segue, Mary, into our next portion here on the PowerPoint. So as you can tell, every contract is different in nature, right? Depending on what you're doing, sales, services, it's going to be different. Independent contractor agreements, NDAs, right? There's so many different types of contracts. They're different in nature, but a lot of them share similar provisions. And here's some of the provisions that you might see out in the vast majority of contracts, right? Integration clauses, choice of law, choice of forum, severability, force majeure, indemnification, assignment. And for those of you who do business with tribes, sovereign immunity clauses, right? So what are these things, you know, and when do we need to have these things in place? So let's start with integration, right? So you have a contract that's being offered to you, and you're reading through it, you're reviewing it, you're remembering the workshop that you attended with Joe Austin, keeping in mind the three elements, three considerations, what's a valid contract, what makes it enforceable, all these things, and you're thinking about your business. How are you going to protect yourself? What do you want to see in this contract? Number one, integration clause. You'll see this in a vast majority of contracts. An integration clause ensures that what is in that contract encapsulates the entire agreement of the parties. So when you see that provision in the contract and it reads that this contract constitutes the entire agreement between party A and party B. And what that means is that if it's not in that contract, it's not part of the agreement, right? That's what the integration clause does. Now, we have a choice of law clause. Choice of law. What kind of law will govern the interpretation and enforcement of the contract? Now, typically, there are rules, legal rules, that will determine what law will apply to a contract. But parties can also negotiate on what law they want to apply to a contract. So if we don't have a choice of law clause, let's say that, again, I'm doing business with Clinton. I have a flat tire over in KNT. I want him to come over and fix my tire. I enter into a contract with him. It's an oral contract. It's not written. Let's say there's a breach of contract. There's a dispute that arises among me and Clinton. Well, what kind of law is going to govern the interpretation and enforcement of our contract, our oral contract that we have? Well, we're in Navajo Nation, so most likely, according to rules of contracting, Navajo law will apply to the interpretation and enforcement of our contract because it's an oral contract. We negotiate it within Navajo Nation. The jurisdiction you're in will really speak to what kind of law will apply. So you can also agree to a choice of law as well, right? So let's say that I'm down here in Tucson, Arizona, and I'm entering into an agreement with Albert up in Navajo Nation. So we have two different jurisdictions, Navajo Nation, Arizona. Which one will apply to this contract? Maybe we want a neutral state, and me and Albert, we agree. Well, let's have Pasquayaki law apply. That is a third party jurisdiction. It's not going to favor us because we're not part of that jurisdiction. Maybe we want New Mexico law to apply. So you can negotiate on things like that. Always remember that every contract is up for negotiation. If somebody's giving you a take it or leave it situation, you might want to consider leaving it. Choice of forum. Choice of forum clauses will determine which court will hear contractual disputes, right? Typically, the jurisdictions laws that apply to that contract, again, the contract between me and Albert, we decide on New Mexico law. Well, most likely, if there's some kind of lawsuit that happens, it's going to go into New Mexico court because New Mexico courts apply New Mexico law. But if you have a New Mexico court and you're saying the choice of law is Navajo Nation, it's going to be very difficult for the New Mexico court to interpret and enforce your contract according to Navajo law because they're separate jurisdictions. So you might want to make sure those things match, right? I have seen situations where people, have different provisions. Severability. A severability clause governs what happens if a court were to strike out any of your provisions in the contract. So if there's a dispute among the parties and the contract goes before a court, and let's say the court takes a look at a non-compete, non-solicitation clause that you have in your contract, and the court says this provision is illegal under Arizona law. It does not meet the requirements for a non-compete, non-solicitation clause. This clause is hereby struck from the contract. Well, the court is only striking that one provision as illegal. What about all the other provisions in the contract? Well, according to your severability clause, if one provision is deemed invalid by a court, then all the other provisions will continue to apply and be enforced in effect, right? Force majeure clause. You'll probably see this. This is the clause that people always talk about. It's the act of God clause, right? Basically, this sets forth circumstances that are beyond the control of either party, which excuses non-performance or breach of contract. And again, the key term here is acts of God, right? So you have a contract to deliver some products from Navajo Nation all the way over to New York. And let's say that there's some civil war that breaks out, right? And you are unable to make that delivery to New York. This is a force majeure situation. It's circumstances beyond your control, and you are not able to perform your duties and responsibilities under the contract. So instead of being in breach of contract, you're excused under the force majeure clause, right? And you always see, within this provision, you always see things like acts of God, floods, fires, earthquakes, war, embargo, those kind of things would constitute force majeure. And you can actually list the type of events that would fall under force majeure. Indemnification clauses. Now, this is another one people struggle to understand, but basically, in its most basic sense, indemnification clause is an obligation of a party to compensate the other for harms or losses that occurred during the acts of the indemnifying or due to the acts of the indemnifying party, right? Indemnifying the other party for harms or losses that occurred due to your acts, right? Let's assume that, you're working for a client and you're developing software like Albert, and Albert hires an independent contractor, me, to help him out with this project to develop software over the next 90 days. Well, let's assume there's a dispute between me and Albert. I don't like his working conditions. He doesn't like the way that I work, all that kind of stuff. And I sue him for breach of contract, and I want some money, and he refuses to pay me money. Well, guess what? I'm now going to sue his customer because his customer owes him money, and that's the way that I'm going to get paid. Well, under your indemnification clause, you agree to indemnify the other party, right? Hold them harmless in that situation. So basically, I can't reach the customers or clients, of Albert because of the indemnification clause, right? Something like that. Or let's say that I do successfully sue, his customers or clients or something like that. Well, then Albert, under his indemnification clause that he has with his client and customers, he has an obligation to compensate them for harms or losses, something like that. That's the indemnification provisions. The assignment clauses that we usually see. Basically, can you assign this contract, your duties and responsibilities under that contract, to somebody else? So if we're dealing, let's say that again, our software company with Albert, and let's assume that I cannot help Albert, but I have a buddy that I know that can probably take my place, and I tell Albert, hey, look, I can't do the contract right now. I can't help you out, but I have another associate that can take my place. And Albert will say, sure. Well, we have an assignment clause that allows you to assign the contract to anybody. So I can assign the contract to my friend, John Doe, who's going to assume my duties and responsibilities under the contract. So that's your assignment provisions. The other one, sovereign immunity clauses. Again, for those who deal with tribal entities and their business, the basic rules of federal Indian law say that every tribe is immune from lawsuits, right? And this it's not just unique to tribes, it's also states. States are immune to lawsuits. The federal government is immune to lawsuits with certain exceptions. And you'll usually see like some kind of clause for torts, right? The Federal Torts Claims Act allows you to sue the federal government for torts. Same thing for the states. You can sue the states for any kind of torts. For tribes, they will spell out in their sovereign immunity clauses whether or not they're going to waive their immunity. So when you're dealing with a tribal government, this is always a point of negotiation, is whether or not the tribe is going to waive its immunity entirely, or maybe it might want to do a partial waiver or no waiver at all, right? So this is usually where the tribe has the upper hand, and it's typically a concern for people who do business with tribes as well, because if a tribe is saying, look, we have sovereign immunity and we're not going to waive it. Well, then what happens if there's a breach of contract and the tribe breaches the contract and you want to sue them, but they have sovereign immunity? What do you do in that situation, right? So this is where you negotiate with the tribe saying, hey, look, I have a lot of concerns. There's a lot of money at stake. Can you do a partial waiver of sovereign immunity? I won't sue you in the state court. I won't sue you in the federal court. But if I have to, I can sue you in Navajo court, right? You might be dealing with Navajo Nation government with a contract. And so Navajo Nation says, okay, we'll do a partial waiver of sovereign immunity for any disputes arising under the contract. If you're going to sue us, you got to sue us in Navajo court, right? So that's the sovereign immunity clauses. So let's take a look at, we have a question from Joseph here. Is this why immediately after 9/11 attacks on the towers, the president announced this was not an act of terrorism to avoid insurance companies from getting out indemnity? And different careful terminology on what we consider war or terrorism. We've seen the fine print on contracts and they have many exclusions. Yes, you are absolutely correct. Again, we go back to the slide, that talks about reviewing, negotiating contracts, right? You got to have that keen eye. You got to be a wordsmith. how are you going to define war or terrorism, right? Those are words that they have their own meaning, plain meaning in the dictionary. If you go to dictionary.com, you put in war, you put in terrorism, they have a definition, right? Well, for purposes of this contract, you might want to define the terms differently or include the definition so that both parties know what constitutes war, what constitutes terrorism, right? That's the fine print that Joseph is talking about. Yes, so he's absolutely correct. Now, let's take a look at some real world examples here. Going back to our first one, the integration clause. So here's what we usually see with integration clause. And I'm not sure if y'all can see this. I know it's kind of small, but if you have a contract with an integration clause, here's some of the language that you might see. We have, let's say, example C. All modifications to this agreement and all waivers of any of the provisions of this agreement to be effective shall be in writing and signed by both parties. That's the amendment waiver clause, single document integration clause. This agreement constitutes the entire agreement between the parties and shall be deemed to supersede and cancel any other agreement between the parties relating to the transactions contemplated in the agreement, right? So there's your integration clause. It's saying anything that's in this contract constitutes the entire agreement of the parties. If there's something that's outside of this contract, not in the contract, you cannot say, hey, look, we agreed to this. Well, if it's not in the contract, we didn't agree to it according to the integration clause, right? So that's typically the language that you're going to see. Again, this agreement constitutes the entire agreement between the parties and shall be deemed to supersede and cancel any other agreement between the parties, right? So basically what they're saying there is, look, we might have talked about this contract before we signed it, but plain and simple, if it's not in the contract, it's not enforceable because we might have discussed it, but what we have here in writing, this is the final product. This is the final draft, right? See that? The title always comes into play. Choice of law clause. Here's what you're going to see with this. By using it, this is Amazon, by the way. By using any Amazon service, you agree that the Federal Arbitration Act, applicable federal law, and the laws of the state of Washington, without regard to principles of conflicts of laws, will govern these conditions of use and any dispute of any sort that might arise between you and Amazon. So you're using the Amazon app, or the Amazon website, you're buying stuff, whatever it is. Well, Amazon has a services agreement that you're going to have to sign. And this is part of it, right? It's saying that state of Washington will apply. And you agree that the Federal Arbitration Act will also apply. Federal law will apply, right? So these are the choice of law, choice of forum clauses that we typically see. Here's specifically the forum. This agreement shall be construed and controlled by the laws of the state of Michigan, and vendor consents to exclusive jurisdiction and venue in the federal and state courts located in or nearest to Oakland County, Michigan. Vendor waives all defenses of lack of personal jurisdiction and forum nonconvenience. So again, typical forum clause that we see, Michigan law is going to apply. This one's interesting because this one actually gets pretty specific here. It says, venue in the federal and state courts located in or nearest to Oakland County, Michigan. Now, you can get that specific with some of these provisions. It's up to you, right? You can just say, hey, look, Navajo law applies. Any disputes will go into Navajo court. Can be as simple as that. Or you can get, as specific as this. Hey, look, Michigan laws are going to apply. You consent to exclusive jurisdiction. You waive the defense of lack of personal jurisdiction because you can't raise that as a defense, and it's going to go into a court located in or near Oakland County. It's very specific. So you can see that there's different ways to go about this. Severability clause, right? This is, again, if a court is looking at your contract and says, hey, this provision here is illegal under state law. We cannot enforce this provision. That is struck from the contract. Well, all the other provisions haven't been struck, so there's still an enforcement effect. So if any provision of this contract is prohibited, invalid, or unenforceable in any jurisdiction, that provision will, as to that jurisdiction, be ineffective to the extent of the prohibition, invalidity, or unenforceability without invalidating the remaining provisions of this agreement or affecting the validity and enforceability of that provision in any other jurisdiction. Right? So again, you can see how that simple concept can just turn into a bunch of mumbo jumbo legal jargon, right? This is why you might need an attorney for some of these things. And we're going to get to AI created contracts and Google contracts in a bit because I have a lot to say about those things. So Force majeure clause. Here's that crazy acts of God, provision that we usually see in contracts. What is a force majeure, right? And this is what Joseph was hinting at here. How do we define some of these things? You see here and let's see, this provision. The following force majeure events that frustrates the purpose of this agreement, and we have A, acts of God, B, flood, fire, earthquake, or explosion, C, war, invasion, hostilities, whether war is declared or not. That's interesting. Terrorist threats or acts, riot, or other civil unrest. So you see the list goes on and on here, what you want to fall under force majeure. So feel free to list anything under there. Again, every place is different, right? You might be in a place where, it's an unstable government, or, something might happen to throw off the contract. That's what I'm talking about with having a forward-thinking mind, right? Think when you're reviewing contracts and you're drafting contracts, think about what happens, right? What will happen in the future? That's the forward-thinking mind. Indemnification clause for professional services. Consultant shall defend, indemnify, and hold the county, its officers, officials, employees, and volunteers harmless from any and all claims, injuries, damages, losses, or suits, including attorney's fees, arising out of or resulting from the acts, errors, omissions of the consultant in performance of this agreement. Typical indemnification clause. Assignment clause. No party shall assign this agreement or any part hereof without the prior written consent of the other parties. Right? So that's something that we see with assignment clauses. You can get a little bit creative with these things. If you're doing an assignment clause, do you want the other party to be able to assign their rights and duties under that contract to a third party, to somebody else? If so, can they do it without your consent, without your knowledge, or are you going to require prior written consent in order for them to do that? Right. Think about independent contracting agreements. That's where we see a lot of this, right? You might be hiring somebody, and that person that you're hiring might hire subcontractors. Well, are the subcontractors liable to you? Are you liable to them, right? So we have to think about that in terms of assignment. So the common question I always get asked, and we're going to get back to our provisions here in a bit, but people always call me up or they visit me after a workshop and say, can I use ChatGPT or some kind of AI to create a contract? Or what about a contract from Google? Can I just Google sales agreement and then pull up the agreement and use that for my business? My answer is that, as you can see in this workshop, a lot of contracts have the same terms and provisions: indemnification, severability, choice of form, choice of law, all that kind of stuff. But every contract is different in nature and it should be drafted accordingly. So I'm not saying that a Google contract is not going to serve your business well, or even ChatGPT, because I actually had a law clerk and a paralegal who used AI to help, with some of their legal work as a jumping off point. But whatever it is that you're using as a jumping off point, as a template, you have to tailor those contracts, right, to your business. Tailor it. Don't just take something, a template, and say, okay, great, and then give it to your client and customer and say, here, sign this, right? Let's see, we have Joseph chiming in here. He says, I asked AI to generate this for me in my next upcoming contract extension for Joe Baya. Clause 9 3/4, the law of surprise, optional mentioning. All right, great. Anybody know about the law of surprise? We got the Witcher going on here. Great. In the event that all standard forms of compensation, payment, barter, or favors have been exhausted, and with mutual consent and a little dramatic flair, the undersigned parties may invoke the law of surprise. Great. As per ancient and probably unenforceable custom, notably observed in the continent. See The Witcher, Book 1. So here's the thing, right? The law of surprise shall entitle the invoking party to that which the other party has, but does not yet know they possess: a goat, chicken, or other mythical creature born at the stroke of midnight. Is this an enforceable provision? That's a question, right? Is this Let's assume, Mary, you are doing business with Joseph Baya here, and he offers you a contract, and it has this in there. What do you make of this?
I will probably call Joe Austin.
That's always a good default. Good default. In which case, I'll offer you a retainer agreement. So the contract go round and round in circles. So if Mary signs this contract and it has this provision, is it enforceable? What do y'all think? Is it an enforceable contract? She signs it.
Yes.
Under Navajo Nation law, yes.
All right. Well, if parties have read this, they understood it, and they signed it, it's an enforceable agreement, right? We have all three elements and three considerations here. The other thing that you'll probably run into if you do sign this contract and you have the law of surprise here is if somebody is going to seek to enforce this contract and a court looks at this, let's say the Navajo Nation courts look at this and they see this law of surprise provision, and Mr. Baya here is trying to enforce it, right? Hey, look, we have this clause. Mary signed it. I'm trying to enforce it. Navajo courts will look at it and say, well, she did sign it, but we probably are not too familiar with the law of surprise. It seems like this contract might not be reasonable in scope, something like that. So it might be that the court strikes this provision. Well, if this provision is struck, what about all the other provisions, right? Well, hopefully Mr. Baya has a severability clause, in his contract, where even though the law of surprise provision gets struck, all other provisions remain in force and effect, right? It's a good example here. So tailor your contracts, right? Ask yourself the following questions. We're running up on time here. What type of contract do I need? It's the exercise that we did, right? However long, 30 minutes ago. Do you need a sales contract, a services contract, independent, NDA, whatever it is? What kind of contract that you need? Think of that. What provisions can I use to protect myself with this contract? Who are you contracting with? Again, remember, there's a difference between contracting with a customer who might be an individual, contracting with somebody who's a merchant, who's another business, because UCC will apply, or contracting with a tribal government. Sovereign immunity applies. So that will determine what kind of provisions are going to go into your contract. And ask yourself, what if? This is, again, the forward-thinking mind. What if this happens? What if that happens, right? That speaks to your force majeure clauses. Well, what if war breaks out? What if the economy tanks because of all these tariffs? What if this happens? What if that happens? Well, protect yourself with your contract and build it in there, right? You might want to have provisions for cancellation, for termination. Build that into your contract. There's a ton of contracts. So again, here's a list of some of them. Some of you might have these contracts. In my experience handling contract cases, I've noticed that the most litigated provisions in contracts, and these are the provisions that cause a lot of ruckus and disputes among parties. These are the provisions that get litigated the most when it comes to breach of contract cases. Number one, scope of services, scope of work. What exactly was that person supposed to be doing? What kind of services were they supposed to render? People argue about that all the time. Hey, look, I said I would only do this. I would not do that, or I would do this for an additional fee, right? Scope of services, compensation, payment, and invoicing. In fact, that is the number one provision I see in terms of disputes regarding breach of contract. Compensation, payment, and invoicing. This is where I encourage my clients and everybody else who engages in any kind of business, products or services. Build out your compensation provisions. Spell out how you're going to do invoicing, right? Is it going to be your invoicing at the end of each month, the beginning of each month, let's say the 15th of each month, whatever it is? How are you going to invoice? What are the payment terms? Net 15, net 30, net 60? It might depend on the industry that you're in, right? For legal services, we have net 15. Payment is due within 15 days. For other people, it might be 60 days. Heavy equipment suppliers, we handle a lot of those contracts, like 60 to 90 days. So really spell out your services and your compensation so everybody's on the same page, so there's no surprises and there's no questions. Shipping and delivery is another one. Where do you ship? How are you going to ship? When does title transfer from seller to buyer? Cancellation and termination of contract clauses. We see a lot of litigation regarding those. Dispute resolution, choice of law, choice and forum. You might have a choice of or a dispute resolution clause that says, hey, look, before you sue me, we got to do binding arbitration first, right? Use of name and likeness. That's one that comes up pretty often. How is somebody allowed to use your name, to use your likeness, maybe for marketing purposes, right? Intellectual property, Mary brought that up. Non-compete, non-solicitation. Those two have a body of law in every jurisdiction that will determine whether or not non-compete and non-solicitation clauses are valid. They are heavily scrutinized by courts. So those are some of the provisions that are highly litigated. Again, I always encourage my clients to be forward thinking, have a keen eye when you're reviewing these contracts. I'm going to show one last example here to demonstrate a contract that's pretty solid, and I'll pull that up here. Any other question? I think Mary, I saw your hand up. I don't know if you want to ask a question while I'm doing this.
Yeah, my question is, when you were speaking to the indemnification, with the work that I do, I'm acting on behalf of the tribe in human resources. Again, it's in regards to disciplinary actions and things like that. So I'm wanting to know what kind of protections are in place for myself should an employee be upset, not agree, things of that nature, to prevent them from considering coming after myself and my business. Thank you.
Okay, really quick before I get to that, Mary, let me just go over this contract. So can everybody see this contract that I have up? I don't know if I switched it over
Yes, we
properly.
can see it.
Okay, great.
Yeah, I can see it.
So okay, so here's a contract. This is from the Gila River community, down in Phoenix. This is Wild Horse Pass. So this is a resort contract that they offer to people who are looking to host an event at Wild Horse Pass. So when you're dealing with resorts, obviously you have your hotel accommodations and then you have your event accommodations, right? So here's the contract that they offer folks. They have guest room accommodations, the number of rooms that you'll need, the rate that they're willing to offer you. So they have all that here. They have what's included in the rate. You see all that spelled out. Cancellation provisions here, right? Any guest rooms canceled less than 48 hours prior to arrival are charged one night room and tax. We have cutoff dates, and again, that speaks to our project timeline, speaks to all these things. Housing methods, so people we gotta use a rooming list to make reservations, concessions, early departure fee, food and beverage minimums. This is for the event itself, for the function space. So what dates are you looking to reserve the rooms? Which rooms are you reserving? How many people? What time is everything going to happen? Food and beverage, gaming, raffles, exhibitors. So if you want to have people come in and set up tables to be vendors and display their items and their services, well, what are the rules and conditions behind that? Here it is, subsection D, food and beverage, food allergies, audio visual. So what goes into that? How much is it? Shipping and receiving provided by event manager. Method of payment, right? You see how everything is spelled out here under section 4. We have A, credit card, B, deposit schedule. Go all the way down here, additional payment terms and details, attrition, cancellation policies, group cancellation. So what happens when you cancel? Who's responsible for what? Security. There's the force majeure clause, right? Conform to the agreement, subject to termination without liability upon the occurrence of any circumstance beyond the control of either party. And there we go. Spelling that out. We have insurance provisions. So indemnification clause, number 12, there you go. We have the ADA. There is a question of whether the ADA applies to tribes, and Gila River is spelling out here whether or not they're willing to accept ADA provisions. Limitations on punitive damages, right? We talked about damages. So neither party shall be liable to the other party for punitive damages, and that's a provision that you see all the time. There's the governing law, right? Choice of law principles, and here's your sovereign immunity clause. Gila River is giving a limited waiver of sovereign immunity, so they are waiving sovereign immunity, not fully. It's a partial waiver. Dispute resolution, there we go. Compliance with laws, resort rules, and policies. There's your assignment provision. Notice waiver, your entire agreement. That's the integration clause, also known as entire agreement, number 22, and the authority that every person has to enter into these contracts. So there's an example. You see it. Everything is right there for you. And I think that brings me to the end of the workshop here. I'll go ahead and take any questions. I got time. I'm not sure if everybody else does, but I think Mary, your question, can you summarize it for everybody again?
I was wondering if the indemnification clause somehow also protects me as a contractor of a tribe who was hired to do work surrounding human resources, in the effect that should a disgruntled employee not agree with some of the findings that I have and the recommendations I provide, will the tribe offer those protections to me as a contractor to
Hopefully.
keep the disgruntled employee from coming after me and my business? Thank you.
Yeah, so again, I've done contract negotiations with Navajo Nation. It can be a real hassle sometimes. They never want to negotiate. But like I said, everything is up for negotiation. If you think it's going to protect your business, as a consultant, put it in there and tell them, look, this is the indemnification provision. Indemnification can go one way or it can go both ways. And again, that's where the fairness comes in, right? I said, when negotiating contract requires openness, requires fairness. So you might want to extend, the same privilege that you have under a certain clause to the other party. If you're going to be granted the ability or the right to cancel a contract or terminate a contract without any consequences, the other party should have the same kind of right. Maybe not the same exact way that they can cancel or terminate, but they should have the same kind of right to cancel or terminate under their circumstances. So that's fairness, that's openness. But yes, you're right. That can protect your business, and think about that moving forward. When you're contracting, with clients and customers. Any other questions?
I have another one.
Yep.
You had mentioned, you gave the example of a contract being signed from an organization in another state. So should the state of Arizona have better parameters in dealing with resolving conflicts and issues that arise? Could we indicate in the contract that everything be dealt with in Arizona versus their state?
Yes. If they're willing to agree, right? So that's again, whatever the parties agree to will become an enforceable contract as long as it meets the three considerations, right? And it has the three elements. As long as it has that, it's a valid enforceable contract. Yeah.
Thank
So
you.
that again, there's a lot of folks who think, that a lot of these things are take it or leave it, that something can't be amended, modified, or negotiated. That's not true. You have a lot of leeway and flexibility when it comes to drafting and negotiating contracts. So there's a lot of different ways that you can do this, but you can see that, just with this workshop, even though you're not an attorney, you can still read these provisions and know, hey, look, something seems off with that, right? And that's your intellectual property clause that you use as an example. This doesn't seem right to me. If it doesn't seem right to you, then most likely something is, fishy going on there, and you might want to consider having an attorney review it. So, and that's my last piece of advice. I'm not just saying this just because I'm an attorney, but if you're a business owner, an entrepreneur, and you plan on doing business at some point, you're going to need to hire an attorney to help you out, whether it's contracts, reviewing, drafting, negotiating. The bigger that you become as a business, the more legal help that you're going to need. And it gets started on the right foot, hiring an attorney when you start your business, have them draft you a standard template for a services agreement or independent contractor agreement. I got a lot of folks, who come to my office and ask me for those agreements. Hey, can you make me a template for a services agreement? Sure. And the thing you have to keep in mind is that as you grow your business and as you conduct business, as time goes on, you're going to go back to your services agreement that you have, your templates, and you're going to modify those agreements according to the circumstances that you run into as you do business, right? So you might be dealing with a difficult client and say, look, I had this dispute with a client. There was no provision in my contract that addressed what to do in that situation. Well, now you want to go back and amend your contract so that your future clients, will understand this is what we're going to do if this happens, right? So the contract is not going to stay the same. It's going to evolve with your business. It's going to be dynamic, as you continue. So keep that in mind. Any other contracts questions? Great. Well, it looks like we're all set. Sophia, I'll turn it back to you. So thanks everybody for your time, and thanks for attending the workshop.